The HOA that hit me with $31,000 in fines for changing my windows lost those $31,000 in court. Their retaliatory resolution, the one they passed in a private session 7 days after I filed my lawsuit, was voided. Their fiduciary breach was entered into the legal record. 3 board members, including the president, chose not to seek re-election when the time came. And the one mistake that handed me everything I needed, the mistake they made without understanding what they were doing, was passing that secret resolution exactly 7 days after I filed, because that gap told the judge every single thing he needed to know about why they had done it. Before we get into all of it, when was the last time you actually read your HOA's governing documents? Not skimmed the summary, read them, because what I found in mine at page 22 is what made this entire case. Stay to the end and I will tell you exactly what to look for in yours. Here are 3 moments you are going to see in this video. First, the cross-examination where I stood in a courtroom and asked the board president to show me where in the governing documents the daily fine amounts were written, $25 per day, $40 per day, and watched him fail to point to a single provision. Second, the moment I read the magistrate's ruling and found the words the association's claim for attorney fees is denied on all 5 theories. All 5. Third, what I did the day after Vincent held a community meeting and described the outcome as a mixed result, a description that left out the $31,000, the voided resolution, and the fiduciary breach finding. I am a pharmacist. I have been in the field for 16 years. The job trains you to read fine print, to track numbers, and to notice when something does not add up. I did not fully appreciate how useful that would be until I was reading HOA case law at midnight after a 12-hour shift. I am divorced, 3 years now, no children. When my ex-husband and I split the house we owned together in Maryland, I was ready for a clean start. Something I owned outright, something quiet. I bought a condo unit in a planned community in the Mid-Atlantic, Stillwater Commons. About 50 units, well-maintained common areas. Neighbors I would eventually come to know as decent people. On paper, it was exactly what I was looking for. I made one mistake at the beginning of this story. I replaced the windows on the 2nd floor of my unit without submitting a written approval request to the HOA board first. I did not know I was required to. I had a vague conversation with the former board president. She lived 2 units down, and when I mentioned I was planning to replace the windows, she said something like, "Oh, just make sure they look nice." I took that as permission. I should not have. The governing documents required written prior approval for any exterior modification. That is on page 22. I had read it when I bought the unit. I had not understood it well enough. That was my mistake. Everything that came after was theirs. The board president when I moved in was a man I will call Vincent. He had been on the board in one role or another for 9 years. His symbol was the process. The formal, controlled meeting where floor discussion was minimal and decisions came down from the board rather than up from the community. His phrase arrived in the first letter from his attorneys. All future correspondence should be directed to the attorney's office, as any communication with board members directly is not appropriate while the matter is under legal review. I had asked to talk to someone. He sent me a lawyer. That was his method. His power was the HOA's legal machinery, real, capable of placing a notice on my property title, capable of accruing fines faster than I could afford. His motivation was control, not the windows. The windows were the occasion. What he did not want was a recently divorced woman who had just moved in and did not yet know her place to start pushing back on how things worked in Stillwater Commons. He had managed homeowners before. He had not managed one who spent her evenings reading case law. Before I tell you what happened when the fines started, I need to explain 4 things, because these are the 4 things that determined the outcome of a 2-day trial. Number 1, windows in a condominium are common elements. This is the thing I did not know and should have. Even though the windows are on your unit, in most condo structures they are part of the building's shared exterior. That means they belong, legally, structurally, to the association as well as to you. Modifying them without prior approval is a genuine violation. I am not going to pretend otherwise. The court ruled on that correctly. The violation was real. Number 2, a fine schedule must be properly adopted to be enforceable. This is the thing Vincent did not know. An HOA board can have the authority to assess fines. That authority is typically granted in the governing documents, but the specific amounts have to be established through a formal process. A published schedule, adopted at a properly noticed meeting, approved through the required procedures, and documented in the minutes. You cannot simply decide that the fine is $25 a day and then make it $40 a day without any document that shows where those numbers came from and how they were adopted. If you do that, a court can void every dollar. Number 3, HOA boards are fiduciaries. They have legal duties to the community they serve, a duty of care, meaning they must act fairly and follow their own procedures, and a duty of loyalty, meaning they must act in the interest of all homeowners, not use the association's resources against individual members they disagree with. When boards use enforcement mechanisms punitively, manipulate elections, or pass resolutions designed to punish dissent, those are fiduciary breaches. Courts have remedies for that. Number 4, timing matters more than boards understand. When a board takes an action, passes a resolution, files a claim, changes a policy, the date of that action is in the record forever. If the timing of that action corresponds exactly to a homeowner filing a lawsuit, that correspondence tells a story. And stories in courts are told through documents with dates. Vincent had been on the board for 9 years. He had probably done versions of this before. What he had not done before was do it to someone who was going to document every date and show up to cross-examine him about them. Before I tell you what happened when the fines started, I want to ask you something directly. Does your HOA have a published fine schedule? Not a general statement that fines may be assessed, a specific document showing how much for what, adopted at a specific meeting with a specific date. Leave your answer in the comments right now, because the answer to that question is what determines whether a court can enforce those fines or void every dollar of them. The violation letter arrived from the property management company in October. My window installation had been observed. The windows were non-conforming. The violation must be cured by removing them and replacing them with windows matching the original specification. I called the property management office immediately. I said, I received the violation notice. I would like to speak with someone on the board. I was not aware windows required written approval, and I would like to understand what the options are. She said, I will pass your message along. The board will be in touch. 2 days later, I received a response. Not from the board, from their attorney. All future correspondence should be directed to the attorney's office. Communication with board members directly was not appropriate while the matter was under review. I had asked to talk to someone. They sent me a lawyer. I wrote to the attorney asking for clarification. What exactly constituted a structural modification, and was there a process for retroactive approval if the windows could be shown to meet community standards in appearance? The response was brief. The windows were non-conforming. The violation must be cured. That meant removing and replacing them with windows matching the original specification. At my expense, I had paid several $1,000s for those windows. Replacing them again would cost the same or more, and I still had not been able to speak to a single board member. I submitted a request to be placed on the agenda for the next board meeting to address them in person. The response came through the attorney. I would not be permitted to address the board until the violation was cured. Fix the windows first, then I could speak. I was not going to fix the windows without being heard. And then the fines started. February, formal notice from the attorney's office. Fines would begin accruing on March 10th, $25 per day for the first 30 days, $40 per day after that. I did the math. 1 year at that rate, over $14,000. 2 years, over $28,000. The fines were not calibrated to motivate compliance. They were calibrated to break someone financially before she could do anything about it. By March, the fines were running. A notice of continuing violation was filed with the county recorder's office, a public record, attached to my property title, visible to any future buyer, any lender, anyone doing due diligence on my unit. In late March, the board's attorney sent an invitation to a video call to discuss the violation. I added it to my calendar. The week of the meeting, no link arrived. I sent 2 follow-up emails, nothing. The date passed without any contact. The board later characterized that session as one I had simply declined to attend. In June, I got a second invitation, a real one this time, with a link, to address the board at their monthly meeting. I prepared carefully. I had photographs of my windows alongside comparable communities where similar styles had been approved. I researched case precedent. I built a presentation. The board gave me 10 minutes. I ultimately spoke for closer to 40. When I finished, Vincent thanked me and said the board would take my comments under advisement. He said nothing substantive about the windows. 2 weeks later, the attorney's letter arrived. The windows remained non-conforming, the violation stood. That was the moment I decided to run for the board. Let me stop here so you understand where we are. 6 months of fines, a title encumbrance on my property, a Zoom meeting that never had a link, a 40-minute presentation that produced no response. I have been silenced, shut out, and invoiced over $10,000 for a mistake I made because nobody explained to me that windows counted as common elements. And I just announced I was running for the board. Here is what happened next. I knocked on doors. I introduced myself to neighbors. I explained what had happened and asked for proxy forms. People responded, more than I expected. Homeowners who had their own frustrations with the board's opacity, with how disputes had been handled, with decisions made without explanation. They signed my proxy forms. They told me they wanted something different. The board distributed proxy ballots ahead of the annual meeting. My name was not on them. 5 names appeared on the official forms, all current board-aligned candidates. The forms were hand-delivered by board members to residents they apparently trusted. Other homeowners, including several who had signed my proxy forms, reported never receiving the official materials at all. I created my own proxy form. I distributed it to every unit I could reach. Those forms were submitted. At the August election meeting, the board's attorney collected all proxies and ballots, took them in a box, did not count them publicly, and announced results after returning from her office. I did not win a seat. I had expected to lose. What I had not expected was what happened 1 week after I filed my lawsuit against the association. The board convened a private session, not at the regular monthly meeting, not in front of any homeowners. They passed a resolution. The resolution stated that any homeowner involved in a dispute over governing document violations would be personally responsible for all legal fees incurred by the association in connection with that dispute. 7 days after my lawsuit was filed. I want you to hold that number, 7 days. The board president later testified under oath at trial that the resolution had been created specifically to recoup attorney fees from me. He said that in court, in a sworn deposition. He said it because he believed it was a legally sound reason. He did not understand what he was actually putting on the record. By the time the case went to trial, my running fine total was over $31,000, climbing every single day. I was representing myself. I could not afford an attorney for a case that might run 2 years, and by that point I had read the governing documents so many times I felt like I was starting to understand them in a way that might actually be useful. I spent evenings reading case law, Delaware condo statutes, court rules, fiduciary duty, and common interest community governance, how elections were supposed to be run, what due process looked like in HOA disputes, what courts had said about retaliatory enforcement. During discovery, the process of exchanging documents before trial, things I had suspected became documented. The proxy forms the board had distributed listed 5 names. My name was not among them. The board president had personally hand-delivered those forms to specific residents. There was no evidence of any standardized community-wide distribution. Multiple homeowners signed declarations confirming they had never received the official forms. The board's own meeting minutes confirmed that the attorney fees resolution had been voted on at a private session on August 8th, before the public meeting began that evening, without homeowner presence, without notice. The lawsuit was filed August 1st, the resolution was August 8th, 7 days, documented in minutes, available in discovery. And the Zoom meeting in late March, the one I had supposedly declined to attend, I found no evidence in the discovery documents that a video link had ever been generated or distributed. The email they cited as evidence of the invitation referred to a meeting time, not a link. I put everything into exhibits, labeled, numbered, organized by date. The trial was set for 2 days in September. I showed up with a binder and a laptop. The board showed up with 3 attorneys. The court that handles HOA disputes in our jurisdiction hears equity matters. The magistrate who presided was thorough and methodical. He asked exactly the kinds of questions I had been hoping someone would finally ask. The board's attorneys presented first. Windows violated the governing documents. No prior approval. Violation ongoing. Fines authorized. Resolution valid. Their witnesses, Vincent and the property manager, were confident. They had done this before. Then it was my turn. I cross-examined Vincent first. I said, "Can you point me to the provision in the governing documents that establishes the daily fine amounts? $25 per day for the first 30 days, $40 per day after that." He said, "The governing documents give the council authority to assess fines." I said, "That is not what I asked. I asked where the dollar amounts, 25 per day, 40 per day, are written in any governing document." Silence. He said those amounts were determined by the council. I said, "At a publicly noticed meeting with a vote recorded in the minutes?" He could not point to that meeting because it did not exist. I walked him through the proxy distribution. I showed the evidence that official forms had been hand-delivered to specific residents while others received nothing. I showed him that my name had been omitted from the official materials. I asked him to explain the process by which that omission occurred. He said any homeowner can create their own proxy forms. I said, "Did the association communicate that option to all homeowners in any written notice?" He could not point to one. Then I asked him about the resolution. I said, "This resolution was passed at a session on August 8th. My lawsuit was filed August 1st. Is that accurate?" He said, "That is the date on the resolution." Yes. I said, "And the purpose of this resolution was to establish a policy for recovering legal costs from homeowners involved in governing document disputes?" He said, "Correct." I said, "Prior to this resolution, had the association implemented this kind of policy for any other homeowner?" He said, "Not formally, no." I said, "And this resolution was passed at a private pre-meeting session, not in front of the homeowners who were present that evening for the regular board meeting?" He said, "It was distributed to them afterward." I said, "So the homeowners who showed up to that meeting were not informed that evening that a resolution had been passed earlier that day, making them personally liable for the association's legal fees?" Silence. The magistrate's ruling came down several months after the trial. I read it at my kitchen table at 6 in the morning. The association won on the core violation. The windows I installed without prior approval were non-conforming. I was ordered to replace them on a reasonable timeline worked out with the new board. I expected that. A court was always going to hold me to my original mistake. I accepted it. But here is what else the ruling said. $31,000 in fines, unenforceable. The association had no properly adopted fine schedule in its governing documents. The daily amounts had been set without published procedures, without proper adoption through required processes. Fines imposed without clear procedural authority cannot stand, especially when the record showed they had been applied in a punitive and disproportionate way against a homeowner who had tried in good faith to be heard. The trespass claim, that my unapproved windows constituted a trespass on common elements, was dismissed. As a unit owner and co-tenant of the common elements, I held a shared ownership interest in those elements. You cannot trespass on property in which you hold an ownership stake. The retaliatory resolution, voided, created in bad faith to punish a homeowner for filing a lawsuit. A resolution passed in those circumstances is not enforceable because associations derive their authority from the collective agreement of their members, and they must exercise it in good faith. Fiduciary breach found. both the duty of care, because of how the election had been managed, with proxy forms distributed selectively, my name omitted, ballots counted privately, and the duty of loyalty, because the board had used the association's legal resources against a dissenting homeowner and then tried to charge that homeowner for the privilege. Attorney fees, denied on all 5 theories the association had advanced. Each party shall bear its own costs. Before I tell you what happened when Vincent held a community meeting and called this a mixed result, I want to ask you something. If you won on the things that mattered most, and then watched the board president stand in front of your neighbors and characterize the outcome as essentially a tie, and you had the right as an association member to submit your own written account to every single homeowner in the community, would you use it? Because I did, and I want to tell you what was in it. But first, go back to the question from the beginning. Does your HOA have a formally adopted fine schedule, not the authority to assess fines? The actual amounts and a document with a date and a meeting and a vote? Leave what you found in the comments. Because what I found in mine, or rather what I found was not there, was the foundation of the court's ruling. Here are the numbers from this case. I want you to hear each one separately. $31,000. That is the fine total that accrued on my property over 2 years. That is the number that was intended to break me financially before I could reach a courtroom. That number is now voided. In writing, in the court record, 7 days. The gap between my lawsuit filing and the secret resolution making me personally liable for the board's legal fees. 7 days. Documented in meeting minutes produced during discovery. That timing, more than anything else I presented, told the magistrate exactly what the resolution was for. $17,000, the amount of community funds spent on legal fees during the 2 years of this dispute. Charged to every homeowner in Stillwater Commons, the people who had nothing to do with this. The board got none of it back. Every homeowner subsidized a legal battle the board picked and escalated, and ultimately lost the parts that mattered most. 2 years. Evenings reading case law after 12-hour shifts, weekends preparing trial exhibits, a 2-day trial where I cross-examined witnesses while the other side had 3 attorneys. 2 years is what it costs to teach yourself condo law and procedure well enough to use it in a courtroom. 3 board members, including Vincent, they chose not to seek re-election when the time came. I did not run again either. I had said what I needed to say in a courtroom, and a magistrate had written it into a permanent legal record. The morning after the ruling came out, I drafted the written summary I sent to every homeowner in the community. It was factual, numbered, dated, every finding, every dollar, every theory the board had advanced and lost. I submitted it through the association's formal communication channel, my right as a member. Vincent held his community meeting and said the association had prevailed on the core violation. He did not mention the $31,000. He did not mention the fiduciary breach. He did not mention the voided resolution. My letter mentioned all 3. I want to tell you something about what it feels like to read a court ruling in your own favor after 2 years of reading case law instead of sleeping. It is not the movie version of that moment. It is quieter. You read it twice because you are not sure you are reading it correctly. You read it a 3rd time to find the part where it goes wrong, where there is a catch, where the thing you thought you won turns out to have conditions. And when you have read it 4 times and the conditions are just the one you expected, just the windows, and everything else is the way the magistrate wrote it, you put the document down on the kitchen table and sit with it for a while. That is the whole moment. No music. Just a table and a document and 2 years of evenings accounted for. I do not know what happened in the conversations that followed. I know that 3 board members did not seek re-election. I know that the new board contacted me within 2 weeks of taking their seats and scheduled a meeting to work out a reasonable timeline for the window replacement. It was a real meeting, a conversation, the kind I had been asking for from the very first week after the October letter arrived. There is one moment from the trial I keep coming back to. Not the ruling, not the cross-examination, the moment when the magistrate asked the association's attorney about the Zoom meeting that never had a link, the meeting I had supposedly declined to attend. The attorney presented the email. The magistrate read it. He looked up and asked one question. He said, "Where in this email is the video link?" There was a pause. The attorney said, "The link would have been generated separately." He said, "Is there documentation that it was generated and sent?" There was not. He wrote that in the ruling. He wrote about the undocumented invitation. He wrote about the pattern of procedure, the things the board said had happened, and the absence of documentation showing they had. I had spent 2 years keeping every email, every letter, every date. The board had spent 2 years assuming I would not. At the beginning I asked, when was the last time you actually read your HOA's governing documents? Here is what to look for when you do. Find the approval requirement section. Whatever it is called, architectural review, exterior modification, structural changes, find it and read it carefully. Make a list of everything that requires prior written approval. Not everything seems obvious. Windows in a condo are not obvious. Mailboxes, fences, satellite dishes, paint colors, check all of them before you change anything. Then find the fine schedule, not the general statement that fines may be assessed. The specific document, amounts, timelines, the adoption process. If you cannot find it, submit a formal written request to the management company for it. If it does not exist as a formally adopted document with a meeting date and a recorded vote, the association may not be able to enforce those specific amounts in court. That is not a technicality. That is the law. Request the financial records. As a homeowner and association member, you have rights to certain documents: the operating budget, the legal expense records, the violation history. Use those rights before you need them in a dispute. The information tells you who this board actually is. Document your own conduct from the first letter, every email you send and receive, every date, every voicemail message and its date, every meeting invitation, and whether a link arrived. Timestamps are not just records, they are the story. My case was made largely by the 8-day gap between a lawsuit filing and a retaliatory resolution. That gap existed in the minutes. I just needed to find it and show it to a judge. And if you make a mistake, if you change something without prior approval, if you skip the form, if you take someone's verbal reassurance as a green light the way I did, own it immediately and in writing. Request the retroactive approval process. Show up to be heard. Do not let pride or embarrassment turn a procedural error into a 2-year legal fight. The board is going to have to meet you partway if you approach it in good faith. And if they do not, if they send you to attorneys before they give you a single substantive conversation, then you know something important about the board, and you know you may eventually need to document that too. I also want to tell you about the neighbor who supported me throughout this. She never testified, she never signed anything formal. She just texted me occasionally with things like, "I saw the community letter, people are talking about it." Or, "3 people on our floor asked me today who the woman was who represented herself." She was the person who told me, months before the trial, that Vincent had characterized me at a neighborhood gathering as a troublemaker who did not understand how community associations work. I thought about that characterization often during the evenings I spent reading the governing documents. Maybe he was right. Maybe I had not understood how the association worked before I started fighting with it. I understood it a great deal better by the time the trial was over. The windows are being replaced. They will look like everyone else's. It cost me 2 years to learn that I should have submitted a form before I called my contractor. It cost the board something too, their credibility, their seats, their claim on $31,000, and the legal fiction that HOA power over homeowners is unlimited. It is not unlimited. It is bounded by fiduciary duty and by the procedures that boards are required to follow. When they do not follow them, courts have remedies. I found one, so I want to hear from you. If your HOA sent you straight to lawyers without a single real conversation, and the fines were already running, what would you do? Would you comply and pay? Would you fight? Would you teach yourself condo law at midnight and show up to cross-examine the board president in court? Leave it in the comments. I read all of them.